Good day, ladies and gentlemen. My name is Samuel Loh, and I'll be discussing the implications of the concepts of sovereignty and non-interference on states' obligation to human rights. So let's look at the UN Charter. In the defense of humanitarian intervention, which is clearly creating a tension between the idea of sovereignty and the idea of human rights, which was discussed by my colleague in the previous slides, there is a tension. And that tension is between state sovereignty and human rights. And this tension is created because the Charter protects both state sovereignty and human rights. And they don't seem to be agreeing. Remember, I said seem. So, let's look further. Under Article 2, subsection 1, subsection 3, subsection 4, we can summarize that number 1, the UN Charter respects sovereign equality, or in other words, sovereignty. And under these three areas, force cannot be used against the territorial integrity, against the political independence, or in any other manner inconsistent with the purposes of the UN. So, we know in these situations that force cannot be used. And therefore, in these areas, it seems to be focusing on how sovereignty is more important because of the territorial integrity form of sovereignty, the political independence form of sovereignty. And then when we look at Article 2, subsection 7, we note that nothing in this present charter shall authorize the UN to intervene in matters which are essentially within the domestic jurisdiction of any state. Aha! Domestic jurisdiction. So, it's not really clearly defined per se, but at a very surface level, it indicates there's a certain realm of activities beyond the interests of the international community, which are protected from outside intervention. And there is a presumption against states having the authority to intervene in other states. And this domestic jurisdiction is protected by this principle of non-intervention. Again, no intervene. So, let's look further. So, however, there are exceptions to the protection of national sovereignty in the Charter. For one, states can only use force against other states if either it's authorized by the Security Council, or in defense against an armed attack until the Council has dealt with the issue. You can look at Articles 39, 42, and 51. So there seems to be an exception to national sovereignty put in the Charter itself. Now, let's look at the case of humanitarian intervention, which many scholars claim it's a form of limiting sovereignty. You're limiting my sovereignty. How could you do that? Now, number 1, let's look at, earlier we discussed purposes of the UN. Now, this is a very broad topic. So let's look at one of the purposes of the UN. The importance of human rights. In Article 1, subsection 3, the first article of the UN, come on. So it is to achieve international cooperation in solving international problems, including or humanitarian character, and in promoting and encouraging respect for human rights and fundamental freedoms for all, without distinction. So, there is a mandate for all members to make a commitment to further human rights, as you can see in Article 2, subsection 3, Article 55 and 56. We see the principle of equal rights and self-determination of peoples, and the members to pledge themselves to take joint and separate action in cooperation with the organization for the achievement of the purposes. That is to promote the principle of equal rights, and self-determination. So fundamentally speaking, we note that every member has a mandate, has an obligation to fulfill what the UN is set out to do. This is just within the UN. Now, even in multilateral treaties that have been implemented, you see there are human rights. These treaties have been implemented protecting human rights, which limit the sovereignty of states. You can see these two conventions on torture, genocide, refugees, race, children, discrimination against women, international covenants on civil and political rights, and on economic, social, and cultural rights. Now, at a summary level, none of these conventions have a specific provision allowing for intervention. Okay? But there's a clear message that human rights are a matter of international concern. So number one, traditionally we used to think it was in the domestic jurisdiction of a state. However, over time, so now before I go there actually, sorry, I'm going to roll back a bit. Traditionally, when you looked at the post-Westphalian era, World War II, human rights violations was always a matter of what happens within the state's borders. Other people's opinions did not matter. Those from the outside don't matter. So that changed with the idealistic League of Nations and subsequently the UN. And with the treaties that have come after that, we notice that human rights are being elevated to the international level, or so-called universality. And the defenders of this intervention argue that the Charter, these treaties, and customary international human rights law, which the customary law is something very common in these treaties, have created a norm of international legal protection of human rights that is at least as important as the norm protecting sovereignty and the norm of non-intervention. So we see now that intervention has been elevated. Now let's look at the case. The Dominican Republic, they faced a decision from the Inter-American Court of Human Rights, which is within the Americas, a regional court, and this court ruled in the favor of the thousands of Dominicans of Haitian descent and Haitian migrants. And the response that the Dominican Republic could muster was to start shouting in defense of its national sovereignty. And so it seems that in this case, when brought into question the idea of human rights, national sovereignty is like the direct counter. It's like, it feels like you were using rock, paper, scissors, and you are playing paper, and then someone else plays scissors, and you're like, what? Human rights and national sovereignty. It's like it goes in counter, apparently, by what is seen here. So the author says, by rejecting the court's ruling as a threat to national sovereignty, the Dominican authorities are undermining the very concept of universal right. So it's clear that this rock, paper, scissors idea, this rock, paper, scissors relationship of human rights and sovereignty seems not to be the case. If not, why did they say undermining the very concept of universal rights? National and universal don't really sound something very similar. But he goes on to say, pitting national sovereignty against human rights is a false contradiction, and it is counterproductive. Human rights are the cornerstone underpinning the rule of law and state sovereignty. So, in further discussion, let's look at what the Dominican Republic's constitution is. In their constitution, the term human dignity and the word protect is contained there. The Dominican Republic itself considers human dignity to be important. But now it seems that when the court tells them, protect human dignity, the Dominican Republic is like, how could you threaten my national sovereignty? And it seems that national sovereignty and human rights are two peas in a pod. They're from the same nature. After all, it's in the constitution. It's not. It did not come from outside. It came from inside, and outside affirmed it. But that in itself is the problem. Many people and scholars and public opinion seems to consider that national sovereignty runs counter to what human rights is. But it is not. They are two of the same thing. Now let's look at how that is the case. First, traditionally fundamentally opposed Peace of Westphalia against the 1948 Universal Declaration of Human Rights. It seemed to put the rights of states against the rights of individuals over here. So sovereignty entitles non-interference in their internal affairs. But there seem to be a few more purely internal matters than how a state treats its own nationals in its own territory. That's the precise focus of the internationally recognized human rights. International human rights obligations of states are solely to their own nationals. So let me read it again. International human rights obligations of states are solely to their own nationals. International human rights are for their own nationals. So that means, what does that mean? Because it has always run counter, right? International and national, that's an inter there, it's different. But when you look back and think, let's read this. In addition to international human rights norms, states, largely irrespective of their will, are bound by the norms of customary international law, obligations erga omnes, and jus cogens. They are bound by a wide range of treaty-based obligations. so long as the obligations do not subordinate states to a higher authority. And they clearly do not in the case of global human rights regime. Even in the UN, the one that has so many members, almost basically every state, nearly every state, are members of the UN. And the UN speaks about sovereign equality. And there is no world government present in this world. The UN is not a world government. Therefore, interestingly enough, this paradigm shift is huge. It's compatible. Human rights is compatible with sovereignty. Human rights advocates typically see the state as the problem, which often is. Think the Myanmar and Rohingya case. But the state is also the principal protector of human rights. So, fundamentally speaking, what's going on at the Dominican Republic, or whenever a state rejects the human rights comments or critiques against them, what they're saying is that don't tell me what I should be doing, because that's what I am supposed to be doing. Ironic, isn't it? Because the state protects the human rights, but at the same time, it seems that the state is the problem. But what is important, at the conceptual level, obligations of human rights and national sovereignty are not mutually exclusive. Rather, they are mutually symbiotic. You focus on your human rights of your national people. People part of your nation are part of your your nationals are part of your state. After all, Montevideo Convention, one of that is to have a permanent population. If your population is there, you have a nation. The population helps you fight for your sovereignty from a de facto point of view and a de jure point of view in the Montevideo Convention. So interestingly enough, there seems to be no conflict. Let's go on. So if there are fundamental human rights which every individual possesses through the virtue of being human, then there also exists an obligation to fulfill those rights. Okay, that we didn't talk about states there. We didn't talk about states there. No states was mentioned. If there are fundamental human rights which every individual possesses through the virtue of being human, there also exists an obligation to attempt to fulfill those rights. So then comes an argument that the Universal Declaration of Human Rights and the other governments are and transnational morality, it's beyond state borders. In principle, this concern for people is rather than blind automatic respect for state sovereignty, which is the case actually. It implicitly acknowledges the claims of a world society rather than merely a system of states. Cue globalization. Right? It's a society, international system, international society. Just replace the word with world with international and you kind of get it, right? But up to today, states still matter. However, it is important that within these constraints, if we cannot have a rule-based order informed by a universal morality, we can at least strive to ensure that decisions to protect human rights are taken by the Security Council in an increasingly democratic, representative, transparent and accountable fashion. So what this line says is that rather than the ideal of having a universal morality, because there are cultural relatives out there that still argues for cultural relativist human rights, but we can at least ensure that the decisions to protect human rights are taken by the Security Council in an increasingly democratic fashion. What does that mean? Because in the Permanent Security Council, China, who seems to be criticized by many about their human rights violations, not just China, many other states as well, they have this power to veto. And when they veto the ability of the UN to intervene, to protect fundamental human rights, then comes an issue with what happened earlier, the idea of state sovereignty against the idea of international human rights, when they are both the same thing. So it is important to look beyond the traditional rhetoric that they run counter to each other, but look at the new paradigm which considers both these things to mesh together, and they are not separate, but yet they are symbiotic. Thank you very much. I'm Samuel.